ये सब चेक कर सकती है मेरे दोस्तों। सबसे पहले खासकर 3 तरीके से जुडिशरी चेक कर सकती है। पहला है कॉन्स्टिट्यूशनल, स्टैट्यूटरी और ऑर्डिनरी। एक एक करके पढ़ेंगे। पहला कौन से तरीके से चेक कर सकती है? कॉन्स्टिट्यूशनल। जुडिशरी चेक कर सकती है कॉन्स्टिट्यूशनल तरीके से, जैसे आर्टिकल 13 में चेक करते हैं कोई ऐसा लॉ तो नहीं आया जो फंडामेंटल राइट तोड़ता है। 245 है, 246 है, चेक करते हैं कि क्या इन्होंने लिमिट में रह के काम किया है। चेक करेंगे क्या इन्होंने लॉ तो नहीं तोड़ दिया, कॉन्स्टिट्यूशन तो नहीं तोड़ दिया, पावर के बियॉन्ड तो काम नहीं कर दिया। ये सब चेक करते हैं। जुडिशरी डिसीजन मेकिंग प्रोसेस चेक करती है। क्या चेक करती है? डिसीजन मेकिंग प्रोसेस। अच्छा, केस था एयरपोर्ट अथॉरिटी ऑफ इंडिया वर्सेस सेंटर फॉर एविएशन पॉलिसी। उसमें बोला गया था टेंडर जो कंडीशंस होती है उसमें कोर्ट इंटरफेयर नहीं करेगी। जैसे टेंडर, जैसे मान लो मैं गवर्नमेंट अथॉरिटी हूं, मैंने टेंडर मेरे दोस्त को दे दिया, तो क्या कोर्ट इंटरफेयर करेगी? तो लॉ कहता है वैसे तो इंटरफेयर नहीं करेगी, लेकिन अगर आप टेंडर आर्बिट्री, जैसे मैंने अभी किया, मनमानी कर रहे हो, मालामाइड वे से काम कर रहे हो, डिस्क्रिमिनेटरी कर रहे हो, दोस्त को दे रहे हो बाकी को नहीं दे रहे, अपने रिश्तेदार को टेंडर दे रहे हो बाकी को अप्रूव नहीं कर रहे, तो कोर्ट इंटरफेयर कर सकती है। वैसे तो नहीं करेगी, लेकिन कब करेगी? जब मालामाइड, आर्बिट्री, बैड फेथ में काम होगा, डिस्क्रिमिनेटरी नेचर को करेगी। एक और केस था एसएस प्रताप सिंह वर्सेस स्टेट ऑफ पंजाब। उसको बोला गया था कोर्ट कोई अपीलेट अथॉरिटी नहीं है गवर्नमेंट एक्शन पे, कोर्ट से तभी इंटरफेयर करेगी जब गवर्नमेंट बॉडीज अब्यूज करेगी, गलत काम करेगी, पावर के बियॉन्ड काम करेगी, तो ही ये होगा। हिंद कंस्ट्रक्शन में बोला गया कि अगर से पनिशमेंट रीजनेबल है, सही है, तो कोई दिक्कत नहीं है, लेकिन अगर पनिशमेंट बहुत ज्यादा डिसएप्रोप्रिएट है, पनिशमेंट बहुत अनफेयर है, तो कोर्ट बीच में आ सकती है। कोर्ट बीच में आ सकती है। आंसर इज यस। वैसे तो वो चेक नहीं करते, लेकिन बहुत ज्यादा है, बहुत गलत है, तो वो इंटरवल कर सकते हैं। चलो, जुडिशियल रिव्यू दो स्टेजेस पे होता है संवैधानिक तरीके में। जो कोर्ट एग्जीक्यूटिव बॉडीज के एक्शन चेक करती है वो दो तरीके से करती है। एक तो एट द स्टेज ऑफ डेलीगेशन ऑफ डिस्क्रिशन, एक एट द स्टेज ऑफ एक्सरसाइज ऑफ डिस्क्रिशन। बोलो, एक बार एट द स्टेज ऑफ डेलीगेशन ऑफ डिस्क्रिशन, एक एट द स्टेज ऑफ एक्सरसाइज ऑफ डिस्क्रिशन। सुनो मेरी बात ध्यान से। डेलीगेशन मतलब पावर मिलना, एक्सरसाइज मतलब पावर का यूज होना। मैंने आपको पावर दिया, कोई भी बच्चा बात करेगा, ओम को पावर दिया, कोई भी बच्चा क्लास में बात करेगा, उसको बाहर भेज देना, ठीक है? डेलीगेशन। तूने पावर यूज किया, वो है एक्सरसाइज। तो जुडिशरी दोनों समय एक्शन ले सकती है। तो पावर
What's the best time to get into a relationship in today's L generation? देखो यार, the best time to get into a relationship in today's generation is सोने के बाद और उठने से पहले का वो जो समय होता है ना, उसमें, you know, that imaginary moment between falling asleep and waking up. What's the best time to get into a relation?
Acted and pursuant to the judgment or under of court or order of court. Protects judge from any criminal liability from the Judicial Act. Extends the protection to the ministry. The staff who may require to execute orders of the court. Such immunity was not extended. Immunity was not extended when such immunity was not extended. These executing or implementing court orders would become enforceable. Act done by a person justified or by mistake of fact, believing himself justified by law. accident in doing a lawful act. Act likely to cause harm but done without criminal intent and to prevent other harm. Being done with the knowledge that it is likely to cause harm, but it is done without the criminal intent to cause harm and in good faith for the purpose of preventing or avoiding other harm to the person or property. Six, seven. Six, seven. Other harm. According to section 19, nothing is an offense. Nothing is an offense merely by the reason of being done with the knowledge that it is likely to cause harm if it is done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harms to person or property. It is a question of fact in such a case where the harm to be prevented or avoided was of such a nature and so intimate justified or excused the risk of doing the act with the knowledge that it is likely to cause harm. It is likely to cause harm. Act of child under 7 years of age. Act of child under 7 years of age. Act of child above 7 and under 12 years of age of immature understanding. According to section 21, nothing is an offense which is done by a child above 7 years of age and under 12 years of age who has not attained sufficient maturity of understanding to judge of the nature and consequences of his conduct on that occasion. Act of a person of unsound mind. Nature of the act is either wrong or contrary to law. Contrary to law. Act of a person incapable of judgment by reason of intoxication caused against his will. Act of a person incapable of judgment by reason of intoxication against his will. Against his will. भाई तेरा 4 महीने बाद है, 4-5 महीने। मेरा तो परसों है CS का। लगे पड़े भाई अभी से कर. Act of a person is incapable of judgment by reason of intoxication caused against his will. He is incapable of knowing the nature of the act, or he is doing what is either wrong or contrary to the law, providing that thing intoxicated himself was administered to him without his knowledge or against his will. Offense requiring a particular intent or knowledge committed by one who is intoxicated. Offense requiring a particular intent knowledge. In case whether an act done in is not an offense unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he has the same knowledge as he would have had if had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. Act not intended and not known to be likely to cause death or grievous hurt, done by consent. Done by consent. Nothing which is not intended to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt, it is an offense by reason of any harm which it may cause, or to be intended by the doer to cause to any person above 18 years of age who has given consent, whether expressly or implied, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to such person who has consented to take the risk of that harm. This section is based on the principle of legal maxim voluntaria not fit injuria, which means he consents suffers no injury. Act not intended to cause death, done by consent with good faith. Act not intended to cause death, done by consent in good faith for person's benefit. Act done in good faith for benefit of child or person of unsound mind by consent of guardian. Nothing which is done in good faith for the benefit of the person under 12 years of age or person of unsound mind by consent either express or implied the guardian or other persons having lawful charge of that person is an offense by reason of law. Any harm which it may cause or be treated by the doer to cause or be known by the doer to be likely to cause that person. However, this exception shall not extend to the intentional cause of death or to attempting to cause death. The doing of anything which the person doing known to be likely to cause death for any purpose other than preventing of death or grievous hurt or curing of any grievous diseases or infirmity. The voluntary causing of grievous hurts or to the implementing to cause grievous hurt unless it be for the purpose of the preventing death or grievous hurt or the curing of any grievous disease or infirmity, the abatement of any offences to the commitment of which offence it would not extend. Word insane person is replaced by person of unsound mind in DNS. Consent known to be given under fear or misconception. Consent known to be given under fear or misconception. According to section 28, a consent is not such a consent as it is intended by any section of BNS if the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act known or has reason to believe that the consent was given in consequences of such fear or misconception, or if the consent is given by a person who from unsoundness of mind or intoxication is unable to understand the nature and consequences of that to which he gives his consent, unless the contrary appears from the context. If the consent is given by a person who is under the 12 years of age. Consent is a misconception of the fact. The consent is given by the person who is in sound mind, intoxication, unable to understand the nature and consequences of it. Gives his consent. Execution of act. Exclusion of acts which are offenses independently of harm caused. According to section 29, the exception in section 25, 26 and 27 do not extend to act which are offense independently of any harm which they may cause or be known to be likely to cause to the person giving the consent or on whose behalf the consent is given. On or whose behalf the consent is given. Act done in good faith for the benefit of the person without consent. Act done in good faith for benefit of a person without consent. The intention of causing death or the attempting to cause death, the doing of anything which the person is doing is known to be likely to cause death for any other purpose other than preventing of death or preventing hurt or the curing of any grievous disease or infirmity, the voluntary causing of hurt or to attempting to cause hurt, for any purpose other than pretending of death or hurt, the abatement of any offense to the omitting of which offense it would not extend. Communication made in good faith. Made in good faith. According to section 31, no communication made in good faith is an offense by reason of harm and benefit of that person. Benefit of that person. Act to which a person is compelled by threats, except murder and offense against the state punishable with the death. Nothing is an offense which is done by a person who is compelled to do it by threat, which at the time of doing it reasonably cause a procedure instant death. Person otherwise his consequences. However, the person doing the act did not have his own accord or form of reasonable apprehension of the harm to himself, short of the instant death, place himself in the situation by which he became subject to such constraint act causing slight harm. Nothing is an offense by reason that is caused or that it is intended to cause or that it is known to be likely to cause any harm if that harm is so slightly that no person of ordinary sense and temper would complain of such harm. Inherent power of court. Inherent power of court. BNS grants High Court special power, inherent powers to make orders necessary to ensure the justice and prevent the abuse of court process. This can include actions like quashing FIR and criminal investigations or proceedings. Supreme Court in Madhu Limai versus State of Maharashtra outlines key principles. State court should not use these powers in specific remedy exists. If specific remedy exists, abuse of process of court or to achieve justice, they should not contradict other legal provisions. Right to prevent defense. Right to private defense. This is also the part of chapter 3, section states that things done in private defense. This is the right of private defense to bodily property. Right to private defense of body and of property. Every person has a right of, subject to the restrictions contained in section 37, to defend his own body against an offense affecting human body or property, movable or immovable. Theft, robbery, mischief, or criminal trespass, or which is an attempt to commit theft, robbery, mischief, or criminal trespass. Criminal trespass. Right of private defense against act of a person of unsound mind. According to section 36, when an act which would otherwise be a certain offense is not that offense, right to private defense against a right to private defense against act of a person of unsound mind or intoxicated person. There is no right of defense. According to section 37, there is no right to private defense. Against an act which does not reasonably cause the grievous of hurt which does not cause death, grievous hurt done or attempted done by a public servant, done by public servant. Against an act which does not reasonably cause the apprehension of death or grievous hurt if done or attempt to be done by the directions of a public servant. Done by the directions of public servant. It is in cases in which there is time to have recourse of protection of public authority. Cases there is time for protection of public authority. According to subsection 2, the right of private defense is not case extends to the inflicting of more harm than it is necessary to inflict for the purpose of defense, when right to private defense of the body extends to causing death. extends to causing the right of private defense of the body extends under the restrictions specified in section 37 to the voluntary causing death or any right to right be of an description thereafter enumerated namely